All right, looks like people are still trickling in. All right, good evening, everyone. Thank you for coming tonight. This event is being recorded, and I'm already seeing some familiar faces here in the crowd. This is the next event in our Progressive or Reform Prosecutor series. I'm Lloyd Liu, the Vice President of Education for APABA-DC, and we are really fortunate tonight to have with us a rock star crew with Larry Krasner, the District Attorney for Philadelphia, Parisa Dehghani-Tafti, the Commonwealth's Attorney for Arlington County and the City of Falls Church, and our moderator, Alice Wang of the Public Defender Service for the District of Columbia. I want to thank our co-sponsors, APABA-DC, HBA-DC, and APABA-VA. And, you know, this is a really important event for us. I think we're really fortunate to have Larry and Parisa here tonight because, you know, they're not only notable for being career defense attorneys who then became the top prosecutor in their respective jurisdictions, but they very much embody the progressive or reform prosecutor movement. And so, you know, this is going to be a great event. I'm going to keep the bios short so that we can cut to the chase. Parisa is the Commonwealth's Attorney for Arlington County and the City of Falls Church. She was first elected in 2019. Prior to that, she had a 20-year record of criminal justice reform, notably as the legal director for the Mid-Atlantic Innocence Project, as a public defender and a law professor at Georgetown and GW. Larry is the district attorney for Philadelphia. He's got over 30 years of experience as a criminal defense attorney in Philly, and he's fresh off a primary win in his re-election campaign. He's also the subject of the PBS 8-part series, Philly DA, that you should all check out when you have a chance. And finally, we have Alice Wang, our moderator. She's the Deputy Chief of the Appellate Division at the Public Defender Service for the District of Columbia, where she's been for 16 years. Before that, she clerked for the Honorable Judith Rogers of the DC Circuit. And I'm happy to announce that the DC Judicial Nomination Commission also just recently recommended Alice for a vacancy on the DC Court of Appeals. So Alice, congratulations. And with that, I'm gonna just pass the virtual mic to you. And thank you all for coming here tonight.
Thank you, Lloyd. Thank you so much for inviting me, and thank you, Parisa and Larry, for joining us tonight. Let's just, I'd like to kick it off by just defining some terms here. So you guys have been both described as progressive prosecutors. Parisa, you said you prefer the term reform prosecutor. What do those terms mean to you, and how do you distinguish yourselves, or do you distinguish yourselves from other prosecutors who call themselves progressive? Whoever would like to answer first, please jump in.
I would like Parisa to answer first.
Larry continuously calls on me in panels, and I don't think fellow panelists are allowed to do that. Professor Abby Smith at Georgetown, who is also a PDS alum, wrote an article over 20 years ago. It was something like, can you be a good person and a good prosecutor? And she answered the question, I think, with a resounding no. But more recently, Professor Angela Davis, also a PDS alum and one of my heroes, more recently challenged that conclusion when she argued in an article called The Imperative of Criminal Justice Reform that a good prosecutor is someone who's committed to reduce incarceration, eliminate racial disparities, and provide second chances. So whether you call yourself reform or progressive, I don't know, but these are what my core beliefs are, is that not every social problem needs to be criminalized, not every crime needs to lead to punishment, that not every punishment needs to be incarceration, and that not every instance of incarceration needs to be so punitive that it leaves no room for rehabilitation.
Larry, do you agree with that, or do you have anything to elaborate on?
I do agree with that. You know, I think that I don't know where I stand on the progressive versus reform terminology. I think Parisa probably actually has the better choice there. Progressive is just a phrase that was out there when people were getting elected long before me, you know, including Kim Gardner and Kim Fox and Aramis Ayala and many others. I suppose reform prosecutor maybe is the better term. And I do agree with that. I guess I would express something else though, which is I think that we in the public interest world, and I still count myself to be in the public interest world, we in the activist space, and maybe I'm not that anymore, but some people still are kind of binary, I mean, and I say this with respect and love to PDS people. And I say, I am a former public defender, so I can make fun of you. But we're kind of binary, I mean, I do public events where people say eliminate all jails and eliminate all cops. Okay, you're an abolitionist. I respect that. That's fine. But it's kind of binary. I mean, it's kind of absolutist. There are more places on this spectrum than lock up so many people that you become the most incarcerated country in the world, as opposed to eliminate all jails and eliminate all cops. There are other places. And I think that those places are where the power is. So I do think that one of the things that a progressive prosecutor is a person who has decided to uncomfortably grab a hold of power. Because a lot of people who are very comfortable with what they do have no power. And so they rail against power instead of taking it and using it in better ways. I won't go on, but to some extent, this is St. George and the Dragon. And my PDS brothers and sisters and my Philadelphia Public Defender brothers and sisters, Innocence Project people, you're St. George, you're going after the dragon. And that's a worthy cause. And I did it for 30 years, so I can make fun of you for it. But it's also okay, like, to become the dragon and have the dragon actually do good instead of evil, because the dragon has some mighty fire. It's okay. There is another way to do this. And so I think that to some extent, we are people who reluctantly hold power. We understand that power does have to be limited. And we trust ourselves to limit it more than we trust the people who would take it if we don't take those spots.
So that's a great segue to my next question, which is, Parisa has also described reform prosecutor in terms of limiting, as she says, imposing hard institutional restraints on the power of prosecutors. Can you describe what some of those institutional restraints can be? And it's interesting because, Larry, you talked about exercising that power for good. And that's, one way to do it. And then another way to do it, or don't want to be binary, but another way to think about it is to voluntarily relinquish power and to impose, institutional restraints on power that would actually, give up power. Parisa, what do you think about that?
Well, I have to give Larry credit for this idea, because I actually got, and you're referring to a Twitter post, and I got the idea while I was watching the documentary, Philly DA, and two things struck me about that documentary. The first being that Larry is always with a coffee cup in hand in there. But the second is that Larry wasn't talking about bringing his own philosophy to the office. What he was talking about is what he just said today, which is the limiting the power of the office. And one episode really struck me that focused on supervision. And Larry's speech that mass supervision is the evil twin of mass incarceration. But his point was that the longer you keep someone under supervision, it becomes counterproductive, and it hands more tools to the system and to the office to punish. And another example is the death penalty or mandatory minimums, for example. When I made the pledge that I was never going to seek and impose the death penalty. Well, a lot of prosecutors will seek the death penalty in a case saying, well, this is a case that really the jury, like the community really needs to weigh in on. This is a very important case. I'm going to charge it as harshly as possible and let the community decide. But really that case ends up being in a plea to life in prison. And that's the power that we're trying to constrain, right? It's the power to coerce people into giving up their freedom, by the way we charge, by the way we punish, by the way we supervise. And, prosecution really should be like a democracy. You don't trust people to behave like perfect angels. but you put instead institutional limits in place so that even when they don't behave like angels, even when you have somebody other than Larry and me in office, the system still works.
So Parisa, when you were at PDS with me, one of the biggest issues that our office was litigating and still does sometimes litigate was the scope of the prosecutor's constitutional duty under Brady versus Maryland to turn over evidence that's favorable to the defense. And I saw on your website that you support open file discovery, turning over everything in your possession to the defense, which is obviously more than what Brady requires. Have you been able to implement that policy? And well, let me just ask you, have you been able to implement that policy?
So yes, but I think it's important to understand what the office was doing before I came in, which is that defense attorneys had to come physically into the office and take notes on files. And it was ostensibly open file discovery, but they literally had to type up notes or write out notes. And any video, they could watch it, but they weren't getting a copy of it. So from day one, we started sending electronic discovery to people. If it was something that we could email, we emailed. If it was something that was too big to email, we bought little machines that just copied very quickly digital media, and we disclose everything. And we do it under a protective order. We do it under, they have to promise that they're not going to disseminate it, so that we don't have videos on Twitter and things like that. But yeah, I mean, it's not hard to provide everything. Sometimes it's hard to get things, and we've had a bit of a struggle getting materials from law enforcement in a timely way. But the philosophy of the office is, if it's good for our case, we're going to disclose it. If it's neutral for our case, we're going to disclose it. And if it's bad for our case, we have to disclose it. And in all honesty, also consider fairly carefully, is our theory actually the right one? Because I'm not interested in creating wrongful convictions or a trial by ambush. And, when you look at the Virginia system, 14 out of the 15 exonerations involved prosecutorial misconduct. And the only way to end that is, with open file discovery, I think.
That's awesome. Larry, what about you? What's your position on open file discovery?
I think the short version is yes, but the thing about it is you have an obligation to turn things over, but there's also some complexity to what you have to gather, right? So we came into an office where it's a cover-up organization. They viewed their obligation when it came to cops to essentially be that they should cover for them. And I think one of the more striking things that we have been able to do is we came up with what we call a police misconduct database. We actually now have a number, I won't say what number, but a spreadsheet and a whole bunch of files that contain troubling information about police officers. Let me put it that way. Some of it's so troubling that it's a reason never to call the officer to testify, and we do that in some cases. Some of it's less troubling, but arguably could be admissible in certain cases. Some of it we don't think is admissible at all, but we still think it should be turned over, right? And because it is a database, when we receive electronically the discovery for a new case and the names and badge numbers of certain officers, it automatically connects to our database and puts the information on that officer into the file, right? So even though we have 40,000 cases a year, even though we have arraignments happening at 3 o'clock in the morning, 24/7, the opportunities for our attorneys to make actual mistakes or to pretend they made mistakes disappear. And then we follow that up with certain strict policies about, you turn this over at the prelim. We're not going to hold all this stuff back until the day before trial and try to induce a plea. You turn it over at the prelim. That's what, so they can cross-examine off of it. Like, that's how this is going to go. That's a big part of it. A big part of it is having a file open, but then what's in your file? Have you followed the Brady obligation to reach out to the close law enforcement agencies and make them give you what they have? Because the PPD, the Philadelphia Police Department, has been a cover-up organization for a long time too. And their latest antic with us is to send us piles of redactions and a few words. when we go after internal affairs files and things of that sort. So, it's, yes, open file is a really good thing, although there are, minor disagreements about what it means with reference to privileged materials of certain sorts. But we totally support open file. We find the bigger challenge in some way to get from local law enforcement, the Brady that they have and that we are required to obtain and turn over.
That's really the challenge. I think that the law enforcement agencies, at least, the main law enforcement agencies that we work with, don't have sort of the deep rooted corruption issues that Larry's agencies do, but it is hard to get that information, and it is sometimes like pulling teeth.
So let me ask you about something a little different. Both of you have said, it's important to you to focus prosecutorial resources on serious and violent crimes and not things like marijuana possession, prostitution, and shoplifting. Larry, I think your office doesn't prosecute shoplifting under $500. Parisa, you support increasing the felony larceny threshold. And you've cited studies showing that lowering that threshold doesn't decrease theft or the value of the objects stolen. I was reading this article recently about what's going on in San Francisco, where the threshold for felony larceny was increased to $950. And retail chains like Walgreens say that they've experienced such a huge surge in shoplifting that they've had to close 17 stores in San Francisco because business is no longer viable, and that they blame this change in law. What do you make of that, and what is your response to that?
That question, who's that question?
Sorry, that was for both of you, but Larry, why don't you answer that first?
Sure. It sounds like a bunch of horse shit. It sounds like what is actually going on is there's been this event that Walgreens perhaps missed. It's called the pandemic. And the pandemic has caused a whole lot of economic displacement in a place where homes are selling for an average of $1.2 million, and they have an enormous homelessness crisis. And then we pile a pandemic on top of that. It turns out shoplifting went up. So who else to blame but the progressive district attorney in San Francisco? Frankly, it just sounds like horseshit. Now, do I have science to support what I'm saying? No, I just have, some common sense. But this is pretty typical of the kind of resistance that you get from institutions when you are a progressive or a reform prosecutor. And those institutions include business associations, large corporations, mainstream media, mainstream politicians, and mainstream party leaders, things of that sort. So it's unsurprising to me.
You have anything to add to that, Parisa?
So, every time I hear a story like that, I think how totally irresponsible the journalism is, and responsible and dangerous, because it's true that there has been some, and it's different in every jurisdiction, but there has been some rise in crime. But the story really is that it's still at historically low points, and even with that rise, you're seeing it across jurisdictions. And Miami had several mass shootings in the span of a week. Nobody said, well, it's because the prosecutor there is not a reform prosecutor that they had mass shootings. And so what you're hearing when you hear that is pundits and politicians really pushing an agenda that would make us turn back towards mass incarceration policies. And if they weren't doing that, they would acknowledge honestly how low crime is in reality compared to sort of multiple year analysis, and how it continues to fall in several other categories, regardless of who the prosecutor is in charge.
So as far as prioritizing, what kinds of crimes to prosecute, in neighborhoods with a lot of gun violence, a lot of people carry guns for protection, but they do it without a permit. They don't go and register their gun or get a license. Do you consider that type of nonviolent gun possession a serious offense that you think your office should be focused on? Parisa, why don't you start with that?
So we're pretty lucky in Arlington that we don't have neighborhoods that experience huge amounts of gun violence. And where we have had it, I've made it clear that it's a priority to prosecute those cases. And in terms of, we also don't have the need to carry around guns because we don't have that issue. And so what I would say is we look at cases on a case-by-case basis. We look at the individual, we look at the mitigating factors, and we have a built-in incentive to make sure that our communities are safe because it's where we live and it's where we go to school. And so yes, we take things seriously, but we also consider what person's circumstances are.
What about you, Larry? Of course, Philadelphia is more like DC, where there's neighborhoods that have you're just standing on your block, minding your own business, and people come shooting, and people. What are your thoughts about nonviolent gun possession?
So just to frame the issue, because I had to deal with this a lot during our recent election, that we have today 236 homicides in about 159 days of the year. We're looking at about a homicide and a half per day. That is bad. And we are also a gun-soaked city because Pennsylvania's laws are absurdly generous towards Second Amendment lunatics. And so Philadelphia supplies New York, supplies New Jersey with illegal weapons. And everybody knows that. In the same way that Chicago is supplied with illegal weapons through Mike Pence's Indiana. That's how this stuff actually goes on. So we are in a different position. I agree with you that when the possession is fundamentally nonviolent, then those are situations where you have to think very seriously about diversion. You got to think seriously about trying to avoid convictions. It's especially sort of complex in Philly because Pennsylvania has done that wonderful thing. They've decided that there's only one city in, one county in all of Pennsylvania where you have to have a permit to carry. And that's the blackest and brownest and poorest one. Gee, what an interesting situation that is.
Right.
So we have to address that issue as well. But we also got to be fair about this. It's not always the most obvious thing in the world that the possession you're dealing with is violent as opposed to nonviolent, or nonviolent as opposed to violent. We have 16-year-olds in Philadelphia, and I've heard these wiretaps. 16-year-olds talking about how the more senior members of their group, which has been involved in shooting, just got killed. And they're saying, well, now it's our turn. Now we have to step up. That's literally what they're saying. And then those 16-year-olds who do not have a criminal record and who are walking around with a gun go out and kill people, right? So the fact that you find someone who is 16, has a gun and has no criminal record may or may not mean that this is a nonviolent possession. It's not always obvious from the circumstances. There isn't always intelligence. That makes it hard. But putting aside the factual issue, putting aside the crystal ball that I can tell when this is nonviolent as opposed to violent, I agree with you. I think that we have to recognize the obvious fact that in a place where you have as much gun violence as we have both chronically and even worse, more recently during the pandemic, you have to accept the obvious fact that there are many people walking around with guns in ways that are illegal, not because they are up to criminal activity or trying to drive gun violence, but because they are afraid. And under those circumstances, we have to take that into account, and we should exercise our discretion in the direction of not giving people convictions that will disable them from participating in the economy and that will actually drive them towards crime. This, I think, is the science that has to be done. The science that, for example, there was a prior administration where they would give diversion for 0.5% of gun possession cases. We came in and fairly early on, we were giving it for 2.5% of gun possession cases. And, the media went crazy. I was being criticized all over the country. We're going to spread mayhem and murder, et cetera, right? But really the relevant point is, okay, so let's look at the 2%. And I'm not saying that's the right number. It's my hope we'll have much bigger percent moving forward. But let's look at the 2% that the old administration would not give diversion. They would have convicted. And let's see how they did after a conviction. And now let's compare them to the 2% who met our criteria and got diversion. And let's see how they do. Because here's the news. Some of the 2% that they convicted were going to commit other crimes, including at times more gun possessions, more shootings, more robberies, things of that sort. If the truth is that we're making ourselves safer by diverting, not charging, or more to the point, diverting large numbers of gun possession cases, then that's what we should want to do, right? And I think, based upon our research, based on conversations with Eric Gonzalez in Brooklyn, another one of our team of progressive DAs, I think that there's a very good argument that what we have to do is compare results when you divert cases and compare results when you treat people who might end up being quite dangerous in a certain way to what happens when you treat them a different way. I think we're actually going to find out that it is the right direction to go.
Larry, one of the issues that you've talked about on your platform is increasing support for victims. Can you tell us what you mean by that, and how do you respond to victims and victims' families who feel like that the only way that they can feel heard and seen and valued is to severely punish those who hurt them, which I think is a fairly common or human reaction?
So I would love to talk all night about this, but Parisa probably has much more interesting things to say than. What has actually happened is that traditional prosecutors have offered victims next to nothing. And so victims have come to believe that justice looks like the death penalty, or justice looks like the longest possible sentence. That is the way we measure the value of my loved one's loss. And that is completely wrong. What do? You take a trauma-centered approach. You provide all kinds of services. We, for example, originated a program in which a bunch of people who have been trained and experienced homicides in their families respond immediately when there is a homicide, and they provide specialized services very intensively for 45 days before those survivors are turned over to the usual victim witness services that have existed in Philly for a very long time, right? So when they're under this crushing weight of finding out that, the 16-year-old has been murdered in front of their house or something like that, somebody's going to help them with the paperwork to get the money for the funeral. Somebody's going to help them to be in communication with detectives who are running around trying to solve the crime. Somebody's going to help them to get to the place where they have to identify a photograph or identify the body, that sort of thing. Someone's going to help them to get them into trauma therapy and to help them to be relocated if there's risks, that sort of thing. It is to a large extent just trying to take care of their needs, which often is just to be present and sit and listen. But it's also to offer them something real instead of just offering them the death penalty, the longest sentence possible. I think a crucial distinction between what we are trying to do, and I'm sure this is true of Parisa too, is we don't view it as, we're not lawyers for victims, right? I mean, that's not just my opinion. That's always been the law. But in Philadelphia, it was so messed up that you would see prosecutors stand up all the time and tell the court that they were the lawyers for the victims. It was actually a very cynical political theory, because what you basically figured is I'm not going to get beat up in the newspaper if I try to do whatever the family asks me to do. So if they like the death penalty, I want the death penalty. No independent judgment about whether the criteria are met. If they want a life sentence, I want the life sentence. No independent judgment about whether it's a first degree or a third degree case, whether the sentence is appropriate. All we want to do is pander to the victims so we look good in the press, because what we're doing is politics. It's not actually justice. And the whole thing is interconnected in that sense. So what really serving victims, survivors, co-victims means is actually keeping your obligation to seek justice. That justice, of course, includes them, but includes them by serving them, not by pandering to them.
Parisa, can you talk about principles of restorative justice and tell us what restorative justice measures you've been able to implement?
Absolutely. So I think the easiest way to understand the restorative justice is to contrast it with the retributive system that we currently have. And the retributive system asks what law is broken, who broke it, and how should they be punished? And incarceration has really become a defining feature of our culture, and to the point where we spend more money on only one thing than incarceration, and that's war. So number one, war, number two, incarceration, and that is our culture. The restorative system looks at it a different way. It asks, what was the harm? What does the person harmed need to heal? And who is responsible for that healing? And the idea is to, rather than sort of separate the person harmed and the person who did it and not answer why and not get true apologies, and it is really to try to bring them together in a way that is really centered around the person harmed, centered around what they need, both immediately and in long-term to heal. And it really decouples this notion of justice with punishment. And it couples the notion of justice with accountability. And what we have right now is a system that is reliant on a passive sort of accountability. We think someone is accountable if they get X number of years in prison. And at the end of the day, that's not really what transforms people. That's not what makes people better. It's not what rehabilitates them. And it's not what prevents them from doing harm again. So in sort of you're centering the victims in the first place, and then allowing for real accountability, what we're doing is creating fewer victims in the long run. So we're healing the people that have suffered and preventing more harm in the future. And in terms of what we've actually done, we bit off a huge chunk in Arlington. And part of the reason why we did it in the way that we did, and I'll explain in a moment what that is because I was very much aware that, and felt myself as a survivor of a crime, that 50% of survivors of violent crime don't actually report. And what that means, as Danielle Surratt, who is much more versed in this than I am, is that 50% of people would rather have nothing than all of the things that the legal system can provide them. And I say that with a little bit of sarcasm. And I'm one of the non-reporters. And so it was really important to me to not just come in and impose a restorative justice program and start sort of referring cases out, but to start a program in the schools, start a program in the community, and start a program in the legal system. And that we do it really from the community up, so that the community is deciding what those programs should look like. So we instituted Restorative Arlington, and we spent, there were 45 community members, including a judge, including me, including people in probation and parole, including victim services, and folks in nonprofits that advocate on behalf of victims, and in schools. What we did was we came up with a strategic plan and to sort of implement RJ in all three of those areas. And now we're in the implementation phase. So we are working with folks like Restorative DC, Restorative Response Baltimore, Impact Justice, and others to create all three of these sort of programs. And we are starting a pilot program in the legal system that addresses harms, that the very serious harms caused by 16 to 24-year-olds. So we're starting sort of there, but in the meantime, we're building capacity and trying to really root it so that when I'm long gone, which will one day happen, that it still survives, and that it survives because it's implemented all across the community.
Larry, you've required your prosecutors to state the cost of the proposed sentence at sentencing hearings, which I think is a very interesting idea. How have prosecutors and judges reacted to that? And do you think that policy has resulted in lower sentences?
Well, I can tell you what I know. What I know is that the number of years of future incarceration that were being generated by the Philadelphia courts, which of course was heavily affected by what we were willing to negotiate and then judges would accept, or what we were requesting at sentencing, but also affected by our not charging certain kinds of crimes. In the beginning of 2020, before the pandemic hit and shut the courts down, was half. of the number of years of incarceration being generated by the last administration. So I know there's been a reduction, but there have been many different measures that got us to that reduction. I also know that, a lot of our attorneys have actually complied with this policy. They have written into their sentencing memoranda what I asked them to write, which is, let's just talk about a really severe case. We're going to ask for as much as 20 years. Let's say 20 years for a stranger rape or something like that. In light of the record of the individual, it's going to cost, 20 times whatever number it is, but let's call it 50,000. It's going to cost $1 million. And judge, even though that's a ton of money that could go into public schools, the crime is so egregious. The history is so egregious. It is so terroristic towards women who live in society that they feel they can't even go out there. Therefore, judge, blah, 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 right? So yeah, it shows up, but it also shows up the other way, often only in the head of the ADA, and that was its real purpose. I didn't think it was going to change what we or judges would do about that small group of crimes that really tear apart society. I thought what it was going to do is make our young attorneys, and the average number of years of experience of an attorney in our office now is about 6 years, which is pretty common for DA's offices. I thought it was going to make young attorneys who are handling a lot of files slow down and think for a minute before they actually ask for jail time for nonviolent offenses, low-level offenses, offenses committed by people who are suffering from drug addiction, like theft offenses, things like that, right? That was the hope, was that they'd say, even though the sentencing guidelines for this chronic retail theft are a year in jail, how am I going to stand up in front of this judge and say, I want the society to spend 50 grand when he stole $11 worth of ever-ready batteries? That's a better use for that money than a teacher. That was really a lot of what the intent was. And I believe at that level, it has been very successful, so that we have attorneys who won't ask for jail time because they don't want to say that, because it doesn't sound right in their head, and they don't want it to come out of their mouths because it doesn't sound right. So, I believe it has been effective. Now, a few judges were loud and proud and stupid about it, one of whom you actually saw in the documentary, who was very critical of us and explained some very interesting things, like there is no mass incarceration. So yeah, but he, by the way, is about to be removed from the bench for ethics violations for about 6 months. So that tells you something there too. But most of the judges in general, they're okay with it. Maybe it was going to slow them down a couple minutes. They'd have to leave a little bit later. Most of them are okay with it. And I think that it is at this point, because we haven't really been enforcing it recently during a pandemic period, it is at this point probably more aspirational than actual. But it is something that we intend to enforce, and we intend to make actual, especially with the new crop of judges coming in and with the new crop of attorneys coming in.
I have so many questions for you guys, but I've already, we have limited time. So I'm going to skip to a question that I know many in our audience want to hear you talk about. Obviously one of the biggest issues in the AAPI community that has faced over the past year is this large uptick in hate crimes, or at least crimes committed against Asians and Asian Americans. What is your view on how these cases ought to be prosecuted? And again, what do you say to people who think that the only way to show that you care about the AAPI community is to punish these crimes by seeking sentence enhancements for hate crimes, or is to punish them as severely as possible? Parisa, do you want to start with that?
Sure. I mean, obviously, no one should tolerate hate crimes, and they make our communities less safe. And they should be looked at carefully. And we've looked at a number of cases. And the job of a prosecutor isn't to jump to a conclusion that something is necessarily a hate crime, but also not ignore that it could be. But when we start talking about, giving the harshest penalties, historically, we've learned that the folks who end up disproportionately prosecuted and incarcerated for the harshest penalties are marginalized communities. So, it's a balance of trying to make sure that the community is safe, but also make sure that marginalized communities don't end up carrying the brunt of that, the harsh punishments. that the system, just veers towards.
Larry, do you have thoughts on that?
Well, I agree with every single word Parisa just said. But I also, I think it's important to recognize that it's not enough, that prosecuting someone for a hate crime when you actually can prove that the motive was racial animus, for example. It has a lot of symbolic significance within the affected community, and we recognize that and we accept that. I do think that someone who commits an aggravated assault and does so with a racial motive is arguably deserving of more punishment, because the act has affected more than one person in the sense that it has potentially terrorized a particular community. How much more, obviously, is a question of subject to debate, but I don't think as involved as various communities get in the determination that something is or is not a hate crime in laws that enable the prosecution of hate crimes, I want to make sure they don't miss the big picture. The big picture is that they are marginalized, and they have been marginalized by government, usually. And the reason that they are vulnerable to these attacks is that marginalization, and that there are things that prosecutors can do to specifically protect those communities that will reduce the number of times when they are attacked. So, for example, immigration may be a big issue within a certain community, immigration status. And if you run a DA's office and you run a police department where people who do not have legal immigration status are not going to report to police, and they're not going to be able to walk into a DA's office or a courthouse without having terrible consequences, then they're not going to do it, and they will therefore become victims. And people who want to victimize them will know this and will victimize them more. The identical phenomenon is true, for example, with sex workers, not a racial group, not an ethnic group, but a marginalized group. If you do not protect them, even though they have a status that is illegal, or people who are, addicted to drugs, if you do not protect them as prosecutors, as a police department, as a city that could be a sanctuary city, for example, when it comes to immigration, if you don't protect them, they will be victimized. If you impoverish them, they will be victimized. If they don't have resources, they will be victimized. So while I do think it is important when you have evidence of an actual motivation to harm that is based upon race and ethnicity, I think is important to prosecute it. And I do think it's deserving of greater punishment than an isolated incident. I also think it can become the shiny object so that we're really not thinking about how we can prevent future victimizations within that group. And that is, above all else, not to marginalize them.
So another, sort of timely topic is that the pandemic has obviously made it much more difficult to bring cases to trial over the past year, and at the same time, much more dangerous to be a defendant locked up in jail waiting for a trial, given the way that COVID-19 has spread so massively through congregate settings like jails and prisons. How has your office handled issues of pretrial detention during the pandemic? Parisa, do you want to start with that one?
Sure. Well, we brought down the jail population 30% in 3 weeks. And we did it by asking every single day for a list from the sheriff's office of everybody who's incarcerated and what their bond was, what their charges were, whether they were on medical or not. And we just went through, we don't ask for cash bail, but that doesn't mean that judges haven't been imposing it over our objection anyway. And so we went through, anyone that had a $10,000 bond and had been locked up for more than a week clearly was not going to make bail. So, we called up their attorneys and said, file for reconsideration. If somebody was on medical, we called their attorneys and said, file for reconsideration. And we worked with the sheriff's office and we worked with the public defender's office. And we worked around the clock to get people released. And because we realized that public safety means protecting the public from the pandemic also. There's lots of ways of characterizing public safety, and keeping people healthy is one of those ways. And we knew that the more people were locked up, the people who worked at the jails and went home to their families and communities, we needed to protect all of those people and sort of the concentric circles of people that go around them. And, the thing about the releases is that if nothing happens, which in the vast majority of those cases, it was not news. Nobody wrote, look at that, 100 people got out and 99 of them went about their business and didn't commit more crimes. And no, there's no follow-up. And the vast majority of people didn't actually commit more crimes. They showed up to court, look at that. They didn't have bail and they still showed up to court when they needed to. The only problem with what we did is that when one person does do something else, the narrative becomes, again, that there's an uptick and it's dangerous to release folks. But we haven't seen that bear out in the actual numbers and in the actual cases. And I'm really proud that we got it down from in the last week of February and the first 2 weeks of March. We got it down 30%.
What did your office do, Larry?
So similar things, Philly is a mess. And so it wasn't that long ago, we had 15,000 people in county custody. By the time I came into office, it was 6,500. By the time the pandemic hit, it was 4,800. And even though our judiciary moved more slowly, within a couple of months, we were down to, I think it was the high 3,000s. It was the lowest level of incarceration in Philadelphia since 1985. But then it started to climb back up. And it has climbed back up. And the reason for it is actually really simple, which is that the court's closed. And so you had a back door of the jail that was somewhat closed and a front door of the jail that was wide open. And we went from, you might say, the happy days of trying to reduce prison population by means similar to what Parisa has described, working with public defenders and with the courts. But the happy days were, it was people on not too serious offenses, for not ridiculous amounts of bail without terrible records. That wasn't so hard to do. It was essentially low-hanging fruit. We find ourselves now, a year later, in a position where the people who are in jail for often serious or very serious offenses. They're in there with a judge's detainer because they were under supervision. The judge is not inclined to remove that detainer. And, no joke, a lot of these cases are shootings. A lot of these cases are shootings, severe stabbings, gunpoint robberies, paralysis shootings. It's fairly serious stuff. Not all of it, but an awful lot of it's fairly serious stuff. So it becomes much more difficult at this point, as you have this process of filtering out the less serious stuff, moving the bar so that more and more groups of people are not too serious, well, maybe a little serious, okay, half serious offenses are getting out. You finally end up with people in custody who are there for much more serious stuff. And it's difficult and it's hard on everybody. And, what's the real solution? The real solution at this point is that the courts have to reopen. We have to be able to resolve cases. I can tell you we had some frustrations. We tried mightily to get the leadership of the courts at that time to do more things by video hearings, under the instructions of the Pennsylvania Supreme Court, to try to use modern technology to deal with the pandemic. We did all that. They were extremely reluctant to do anything that was not how they had done it. And when they did it in this almost reckless way that had no regard, for the safety and privacy of, let's just say, a 12-year-old who had been raped, or for people who could be in grave danger by broadcasting to the entire world the entire contents of the trial, things of that sort. So it was messy, and it's a mess. And right now we have gone back up to about, I think, at the low 5,000s is where we are. And there is more work to do. But I will say this, thank goodness that people before us, and that we, before the pandemic ever hit, took a jail population from 15,000 down to about 4,800. Because can you imagine the mayhem that would have occurred, the super spreading that would have occurred in that kind of an environment? And no, we did not have, we did have some deaths, but we had a number of deaths, and no deaths is okay, but we had the number of deaths that we had between prison staff, and there were one or two, and inmates was approximately at the level of death of the regular population, right? Nothing good there, but it also wasn't one of the biggest super spreaders in the United States. And 5 out of the 10 worst super spreaders early in the pandemic were jails and prisons. So that's where we are with all of that.
Lloyd, do we have time for one more question, or do you want to start?
Yeah, let's
wrapping?
take one more.
Okay. So, I think, Parisa, you already alluded a little bit to this about, making lasting change. A lot has been talked about in terms of, it's not just policies that make a difference, but a change in culture in the office. That as long as there's a culture of just wanting to win, as opposed to trying to do justice, that policies are not going to make a difference. What kinds of culture changes have you tried to make, and do you think those, what kind of success do you think you've had? We'll do very quickly, Larry first, and then Parisa.
I'll be real quick. So we fired some people. One of them just ran against me and lost, by the way. So beware who you fire. We then did a lot of educational programs to bring around those who could be persuaded. Those educational programs didn't just teach them the policies, but why we have those policies. And then we made our top priority recruiting. And we went all over the country to try to hire the best and the brightest, and tremendously increased diversity in the process. That's a lot of it. And some of it is just time. It's just the accumulation of a way of thinking and conversations over time. We still haven't broken the knot, and I will be quiet after this. We still haven't broken the knot of coming into an office where all your supervisors are experienced people who came up under a different system. And they are training your bushy-tailed and eager reformers that you have recruited from all over the country. And let us just say their instincts are not quite the same sometimes as the administration. That's a tough slog. And that may be the thing that takes a decade, or it takes 8 years or something like that. So that your supervisors are actually your people. They're the ones who really are with the mission.
So the drawback of having a small office is that I don't have Larry's budget. So I can't hire a whole bunch of people to do data. But the upside is that I am in constant conversation with everybody. And during the transition, I had everybody fill out a questionnaire, which was fairly lengthy. And it really went towards values and philosophy. And it was sort of clear who should stay on and who would not be a good fit. And we have, like I said, constant conversations. There's an area outside of my office where every single day you will find half of the attorneys having lunch together. And we talk about things like restorative justice. And we talk about, decoupling punishment and justice. And the notion of those two. I look at people's sentencing arguments. And if they're saying things like, this person needs to get 20 years in order to serve justice, and like sort of conflating the two things, and that's the only just result, I rewrite it, or I have them rewrite it. And so the ability to talk to everybody on an almost daily basis has helped change the culture dramatically. And I have an entirely new leadership team. And that was that was advice that Larry gave me. He said, bring in your own leadership team. And I did that. So the downside is that it's going to be easy to switch back. But the culture of the courthouse, however, is a different story. That is taking a very long time. And it's been a real challenge, especially with some of the judges.
Well, that about gets us to the end of our event tonight. But Larry, Parisa, Alice, I just want to thank you all for being here tonight. I mean, it's just incredibly informative and important, really. And so thank you all tonight. I'd like everybody in the crowd, no one can hear you, but please give a virtual round of applause. We're all just kind of feeling it, imagining it right now. Yeah, there you go. All right. Well, thank you so much, everyone. We really appreciate it. And best of luck. And we'll be watching and paying attention to what you're all doing, because you're really lighting the way for everybody else.
Thank
Good night.
you.
Thank you.